A sui generis database right is considered to be a property right, comparable to but distinct from copyright, that exists to recognize the investment that is made in compiling a database, even when this does not involve the creative aspect that is reflected by copyright. Australia. No specific law exists in Australia protecting databases. Databases may only be protected if they fall under general copyright law. Australian copyright law regarding compilations is currently examined in case law, where an initial case, Telstra v Desktop Marketing Systems, was successfully litigated by Telstra, establishing a database right. However, this was overturned in a later ruling, ICETV v 9 Network, where sufficient creativity was established as the defining characteristic of copyright. Brazil. Although Law No. 9610/1998 confers database owners exclusive rights specifically for copying, distribution and translation of databases, it also states that this right is contingent upon the database being the result of an intellectual creation, therefore offering no sui generis database rights. European Union. In European Union law, database rights are specifically coded laws on the copying and dissemination of information in computer databases. These rights were first introduced in 1996. On the 11th of March 1996, the Council of the European Union passed Directive No. 96/9 EC of the 11th of March 1996 on the legal protection of databases, giving specific and separate legal rights to certain computer records. The law calls these database rights. Rights afforded to manual records under EU database rights laws are similar in format, but not identical, to those afforded artistic works. Database rights last for 15 years. Each time a database is substantially modified, however, a new set of rights are created for that database. An owner has the right to object to the copying of substantial parts of their database, even if data is extracted and reconstructed piecemeal. Database rights under the EU are created automatically, vested in the employers of creators, and do not have to be registered to have effect. Database rights are independent of copyright. The arrangement, selection, and presentation of the data may be protected by copyright, while the database as a whole can be protected by database right. Russia. In Article 1260 of the Civil Code of Russia, a database is a collection of independent materials presented in an objective form, which are systematically arranged in a way that these materials can be found and processed by a computer. A database need not be registered to enjoy legal protection, but the Civil Code of Russia provides for the registration of rights, which is useful if the claims are disputed in court. United Kingdom. On 1 January 1998, the Copyright and Rights in Databases Regulations 1997 came into force. Under Regulations 13 and 14 of the regulations, database rights automatically subsist if there has been a substantial investment in obtaining, verifying or presenting the contents of the database. Such rights remain in force under Regulation 17 until the end of the 15th calendar year from the date on which the database was first made available to the public. During that period, database right will be infringed by any person who, without consent, extracts or reutilizes all or a substantial part of the contents of the database, whether all at once or by repeated extractions of insubstantial parts. On the other hand, any lawful user of the databases has a right under Regulation 19 to extract or reutilize insubstantial parts of the data for any purpose, and that right cannot be restricted by the database owner. The term substantial is defined to mean substantial in terms of quantity or quality or a combination of both. United States. Uncreative collections of facts are outside of congressional authority under the Copyright Clause of the United States Constitution. Therefore, no database right exists in the United States. Originality is the sine qua non of copyright in the United States. This has not stopped database owners lobbying for the introduction of such a right, but so far bills to introduce it in the U.S.